45 has been clobbered by the courts, and there may be more to come. The third branch of government last week offered an assertive restraint on the power of 45, and there's likely to be more bad news for 45 from the federal court system as the U.S. House's impeachment inquiry progresses. 7 separate federal courts dealt major blows to 45 on everything from his immigration policy to attempts to get his tax returns. But the biggest bludgeon came from the D.C. Circuit Court of Appeals, that esteemed bench that regularly handles separation of powers questions. The circuit sided 2-1 with the House over its subpoena for 8 years of 45's accounting records. 45 now could ask the circuit court for additional review of the case to go directly to the Supreme Court. He has less than a week to decide until the clock runs out to stop his accounting firm Mazars USA from complying with the subpoena. Though our journey has been long, we find ourselves at the end of a familiar tale, Judge David Tatel wrote in the appellate opinion, diving deep into the judiciary's role in impeachment proceedings and other congressional investigations on Friday. The circuit court called the House subpoena valid and enforceable, explaining that the House was pursuing an investigation that could result in constitutional new laws. Federal courts have so far been asked to weigh in on relatively few standoff centrals to the Ukraine-focused impeachment inquiry. That could change depending on the Democrats' boldness and how encouraged they feel following the routing of 45's legal arguments. Federal judges throughout history haven't often come down on protecting the squatter from investigation. Instead, they have in several situations delivered to prosecutors and the impeachment investigations and the House materials they seek, sometimes exceptionally fast. 45 so far has done his best to delay information from getting into the House's hands. His White House counsel wrote to House leadership early last week to say it wouldn't cooperate in the impeachment inquiry. The letter invoked the Constitution and due process for the squatter. The dissenting judge on the circuit's tax return case, 45 appointee Naomi Rao, appeared to endorse many of the White House's arguments. Other issues, even closer to the Ukraine impeachment inquiry, could move into the courts in the upcoming days. The House subpoenaed U.S. Ambassador to the European Union, Gordon Sondland, who became the first major witness blocked by the administration from testifying on the Hill impeachment probe. Sondland agreed to testify this Thursday, but if the administration blocks him again, the House could ask a judge to intervene. What the history could tell us in this case: in past impeachment proceedings, the courts have undermined the squatter's wishes. During Whitewater, Bill Clinton was forced by a unanimous Supreme Court to testify under oath in a civil lawsuit, which led to his impeachment for lying and obstruction of justice. During Watergate, Richard Nixon faced multiple fast-moving court cases that ultimately forced vetoes to Congress and prosecutors that prompted his resignation before the full House could vote on articles of impeachment. In a hearing Tuesday, Chief Judge Beryl Howell of the D.C. District Court, the first-line trial court in most separation of powers fights, grilled the Justice Department, a lawyer who argued to keep information known to the executive branch away from the House. Howell pressed administration attorney and legal precedent what Howell must decide under the law based on past decisions from courts above. When the lawyer suggested that a judge in 1974 would not have handed a grand jury's collection of evidence to the House of Representatives during Watergate if the case had arisen today, "Wow," Howell exclaimed. Howell also bluntly told the Justice Department's legal team she would need to back the House in its needs during a formal impeachment proceeding. By my reading of the Supreme Court and D.C. Circuit Law, I owe enormous deference, if not absolute deference, when it comes to the exercise of the impeachment power to how the House decides to conduct itself, Howell said Tuesday. Michael Gerhardt, a CNN analyst and University of North Carolina law professor, pointed to moments in the Howell hearing as an example of how far 45's legal team has swerved from history. The argument shows not just how much disdain they have for the settled law. Most judges would just recoil at that, Gerhardt said. The circuit court in its tax returns decision Friday appeared to signal as much. They discussed in the majority opinion 4 decades of squatters previously had disclosed their tax returns, and Congress would be well within its rights to ask for the tax returns or make law forcing squatters to disclose them. Congress can require the squatter to make reasonable financial disclosures, the court wrote. The language could weigh almost against 45 in another ongoing case where he is trying to stop Congress from requesting his New York tax returns under a new state law. Judge Carl Nichols, the most recent 45 appointee, has not made any decisions yet. The circuit's opinion is more likely to embolden Democrats. Before House Speaker Nancy Pelosi announced the impeachment inquiry involving Ukraine, she emphasized the Democrat involved strategy involved the courts as the committees investigated several allegations against the squatter. We are taking the work of the committee into the courts, Pelosi said at a September 12th news conference. Since launching the impeachment inquiry last month, Pelosi has described White House defiance of the investigation as an abuse of power and further evidence of obstruction, which that's true. There's some possibility that if Democrats turn to the courts for more help in the Ukraine investigation, it could be a risky strategy, Gerhardt said. The courts are likely to not want to get involved in this unless prompted, according to the legal scholar, and while lower court judges will likely stick to historical decisions that hurt squatters under investigation. Gerhardt added it's possible the U.S. Supreme Court could be more sympathetic to 45's legal arguments. Ralph's dissent, in particular, could be a preview of the thinking of some Supreme Court justices. She notes the question of whether the House can subpoena the squatters' tax returns for a possible legislative reason has never been squarely addressed by the Supreme Court. Ralph points out that Congress has not yet authorized an impeachment inquiry, meaning to her it's abusing its legislative power with the tax return subpoena. The lack of a formal resolution authorizing the impeachment proceedings is a point White House counsel Pat Cipollini also raised. Allowing the committee to issue the subpoena for legislative purposes would turn Congress into a roving inquisition over a co-equal branch of government, Rao wrote. The writing has been on the wall since spring that 45 would have difficulty blocking House subpoenas. Two trial level judges have made it clear Congress gets what it says it needs. To be sure, there are limits on Congress's investigative authority, but those limits do not substantially constrain Congress. Judge Amit Mehta of the D.C. District Court wrote in May, deciding that the House Oversight Committee could obtain 45's records from his accounting firm. The ruling Friday from the D.C. Circuit, again siding with the House, was to appeal to this decision and upheld Mehta's ruling. This court is not prepared to roll back the tide of history, Mehta added, referring to the Nixon-era congressional investigative steps that led to the Watergate impeachment hearings, as well as requests Congress made during Whitewater before opening the official impeachment proceedings against Clinton. Mehta ruled less than a month after receiving the case about 45's accounting records, which amounts to lightning speed for a sometimes circumspect court. Judge Edgardo Ramos in the Southern District of New York made a similar decision to Mehta's on a case about a subpoena for 45's bank records from Deutsche Bank and Capital One, taking only 23 days to rule. 45 is still awaiting a decision from the Second Circuit Court of Appeals, which is reviewing the case that was before Ramos. Both Deutsche Bank and Capital One have said they wouldn't have 45's tax returns to give to the House under that subpoena. Yet the House could still get private financial details. Not all judges have been as firmly against 45. Some of the cases between 45 and the House have landed in the hands of this squatter's appointees, including the D.C. District Court, which has 4 new judges. So far, those judges have moved more slowly and taken up questions related to Congress. One 3-month-old case, for instance, before Judge Trevor McFadden over a House subpoena of the IRS for 45's tax returns, declined to expedite the case and won't have a hearing until November. Yet much depends on the draw. The process that randomly assigns a judge to a case, and yet another case between the House and 45 regarding forcing former White House counsel Don McGahn to testify. Attorneys for the House sought Howe as the adjudicator. When she said there was no good reason she should have the case, the court spun its wheel and assigned the matter to Judge Ketanji Brown Jackson, an Obama appointee. Jackson is set to hear arguments over the McGahn subpoena on the House probe of whether 45 obstructed justice on Halloween. Even outside the House versus 45's proceedings, federal judges and lower courts came down harshly against the squatter last week. On Friday alone, 4 federal judges rejected the squatter's immigration policies. One judge ruled against the squatter's emergency declaration to build a border wall, while 3 others tore apart the administration's rule that would make it more difficult for immigrants who rely on public assistance to get green cards or visas. And on Monday, Judge Victor Marrero of the federal court in Manhattan ruled against 45 2.5 weeks after getting a case regarding a subpoena of 45's tax returns. The trial-level judge decided 45 couldn't block the state prosecutor from obtaining his tax returns. The ruling sits outside of the fights between the squatter and Congress, yet Marrero worked into a 75-page opinion ways to slash at the protections 45 has asserted, and his administration's legal approach entirely. This was not a court sympathetic to the White House in an inter-branch fight. Morrell, in his opinion, called assertions that 45 is above the law while he serves as a squatter is repugnant to the nation's government, structural and constitutional values, and again, 45 is appealing.